So, prosecution. What is prosecution? It is the second pillar of the Philippine criminal justice system. It is the process or method whereby accusations are brought before a court of justice to determine the innocence or guilt of the accused. It is also the one who gathers necessary evidence with the help of the law. Prosecution determines the existence of the prima facie case. It also file and prosecute the case in the court. So, sabi nga, determine the existence of prima facie case. Basihan na there is really a crime committed. So, so what is the role of the prosecutor? The role of the prosecutor, serving as the lawyer of the state or government in criminal cases. The prosecutor is automatically considered as officer of the court. At the same time, the prosecutor is formally a member of the DOJ under the executive branch of the government and is thus independent from the judiciary. Kinatawan o representative ng ating gobyerno sa mga criminal cases na abogado ng people of the Philippines. So, sa mga hearing appearances, halimbawa, I am Public Prosecutor Jeaneth de la Peña, respectfully appearing for the government, Your Honor. So, they will be the one to serve as the lawyer of our government. So, what is prosecutorial discretion? It is the prosecutor screens and evaluates the documents in order to decide whether to accept or reject the case for prosecution. Ang sunod naman natin ay ang selective prosecution. So, the responsibility of the prosecutor is to evaluate the evidence that the police have gathered and decide whether it is sufficient to warrant the filing of charges against the violator. Next, legal factors considered by a prosecutor under selective prosecution. Number 1, the legal strength of the case or kung may laban ba ang kaso. Number 2, the suspect is in fact guilty. Next is the willingness of the witnesses to testify. Kung yung lahat ba ng witness ay willing mag-testify against the offenders. So next is the likelihood that the prosecutor can legally prove the defendant's guilt. We have also the controversial expression of prosecutorial discretion. The decision to mitigate the defendants through 1. Reducing the charge. The prosecutor uses these charges imbes na murder magiging homicide. So, dropping the multiple counts to leave a single charge. The prosecutor can develop several charges and come up with only one single charge or yung complex crimes. So, next is recommending leniency to the court at sentencing parallel prison sentence. If the accused pleaded guilty and he is a first-time offender or a minor, the prosecutor can recommend for a lighter sentence. So, only stage that the prosecutor can make recommendations. So, who composes the prosecutor? 1. The public prosecutor or yung tinatawag na fiscal. Under the fiscal is the public prosecutor, we have the state prosecutor, the provincial prosecutor, city prosecutor, and the special prosecutor. Sa ano naman is the attorneys in private practice. Sila yung nagre-represent the parties or the complainant or respondent in proceedings before the public prosecutors. Number 2 is the public defender such as PAW and other legal age lawyers. So, ano nga ba ang duties ng prosecutor? Number 1, evaluate the police findings referred to them or other complaints filed directly with them by individual person. Example, private citizens who are victims or have knowledge of crimes like governor officers in charge or enforcement of the law violated. Number 2, file corresponding information in proper count on the basis of their evaluation of the proofs at hand. And last, prosecute the alleged offenders in court in the name of the people of the Philippines. So, ang prosecutor ay ang ating mga taga-usig. We have also the preliminary investigation. Sa preliminary investigation, an inquiry or proceeding for the purpose of determining whether there is a sufficient ground to engender a well-founded belief that a crime cognizable by the RTC has been committed and that the respondent is probably guilty thereof and should be held for trial. So, determine yung probable cause, merong dahilan o basihan na isinampa ang kaso sa hukuman. So, officers authorized to conduct preliminary investigation. We have the provincial or city fiscals and their assistants. Number 2 is the national and regional state prosecutors. Such other officers as may be authorized by law. We have the nolle prosequi. It is yung tinatawag na request made the prosecutor to the judge for approval to terminate further criminal prosecution against the suspect. So, ano nga ba ang uses ng nolle prosequi? Ito yung reduce case overload. Number 2, reduce backlog. And last is the reduce delays in bringing defendants to trial. Meron din tayong tinatawag na arraignment. Sa arraignment, ito yung legal mechanism whereby an accused is brought before the court wherein the complaint or charge against him is read by the clerk of court in the presence of a lawyer and the prosecutor, in which the accused is to announce his plea. Ito yung pagbasa ng sakdal sa akusado. Halimbawa, ikaw, Juan de la Cruz, ay inaakusahan ng sambayan ng Pilipino, etc. Next is plea bargaining. It is the process of discussing or negotiation between the defense counsel and the prosecutor aimed at reaching an agreement whereby the prosecutor uses discretion to obtain from the judge a lighter sentence in exchange for the defendant's entering a guilty plea. So, ano nga ba yung advantages ng plea bargaining? Meron tayong 1, allows the court to control over crowded dockets. Number 2, allows the prosecutor to secure convictions in bad arrests. Number 3, a necessary discretionary tool for tempering the letter of the law with an individualized justice. 4, acts in the best interest of society rather than on behalf of the victim. Ito din yung 5, saves victim from humiliation and trauma. Number 6 is, there is no trial. Yun yung advantage ng plea bargaining. So, meron tayong advantage. Of course, meron tayong disadvantage. Disadvantages rather. Number 1, lowering of cases demoralizes the police. So, halimbawa, mga high-profile na individual yung mga arestuhin. So, ayun, ang mangyayari, may bargaining na magaganap, yung bababa yung moral ng mga police dahil doon. 2, provides an opportunity for the prosecutor and defense counsel to place their economic and occupational needs ahead. 3, mostly is favor of the defendant. 4, it is not an evidence of repentance, legitimacy of punishment and rehabilitation. Hindi porket inamin niya yung kanyang nagawang krimen ay pinagsisisihan niya na yun. So, number 5, it determines the basic premise of crime and punishment. So, destructive of the adversary method of justice. So, number 7, defendants are dissatisfied. So, meron tayong tinatawag na prima facie evidence. So, ano nga ba ang prima facie evidence? It establishes a fact and unless rebutted or explained by evidence becomes conclusive and it is considered as if fully proved. It denotes evidence which, if unexplained and uncontradicted, is sufficient to sustain the proposition it supports or establish the facts as to counterbalance the presumption of innocence to warrant a conviction. Ito yung paunang impresyon sa isang kaso. Yung katiwa-tiwala or kapanipaniwala yung mga inihaing ebidensya. Pero hindi yun ang tinatawag na proof beyond reasonable doubt. So, kasi ang proof beyond reasonable doubt, yun yung totoong impresyon doon sa kaso. Ang tinatawag na prima facie ay paunang impresyon sa isang kaso. Ito naman, take note. Kung walang prima facie evidence, walang maisasampang kaso. Ang prosecutor, kailangan makapag-establish ng probable cause bago makapag-file ng info sa hukuman. So, meron din tayong tinatawag na complaint. It is a sworn written statement charging a person with an offense subscribed by the offended party, any peace officer, or the public officer charged with the enforcement of the law violated. Bago nirereklamo mo or hinahabla mo yung tao, ang pwedeng maghabla ay ang offended party or victim or complainant. Ang peace officer or ang public officer na charge sa pagpapatupad ng mga batas. So, meron tayong requisites of complaint. So, number 1, written statement or under oath or sinumpang salaysay. Number 2, signed either. 3, offended party for any peace officer or public officer charged with the enforcement with the law violated. Meron tayong complaint. Ito yung ipina-file sa prosecution. Ang information naman ay ipina-file sa court. Tandaan, complaint sa pina-file sa prosecution while ang information pina-file sa court. Sinong pwedeng mag-subscribe sa pag sa prosecution ay pina-file sa court? Sa complaint. Ang complaint na pina-file sa prosecution, ang pwedeng mag-subscribe doon ay ang offended party, peace officer, or public officer. Take note, complaint, ipina-file sa prosecution, ang pwedeng mag-subscribe doon ay offended party, peace officer, and public officer. Next, information na ipina-file sa court, ang pwedeng mag-subscribe ay ang public prosecutor or ang mga fiscal natin. So, ano nga ba ang purpose ng preliminary investigation? 1, of course, to protect the innocent against hasty, malicious, and aggressive prosecution. 2, to spare him from trouble, expensive, and anxiety to a public trial. Number 3, to protect the state itself from useless and wasteful nights. So, kung hindi nga naman pala worthy yung ipaglalaban mo, ay bakit mo pa ipupush? Kailangan talaga ng preliminary investigation para sigurado. Sa section 2, officers authorized to conduct preliminary investigations. A, provincial or city prosecutors and their assistants. Letter B, judges of the municipal trial courts and the municipal circuit trial courts. C, national and regional state prosecutors. And last, other offices as may be authorized by law. So, other offices, under ng other offices na authorized by law, we have the COMELEC or the Commission on Elections. So, ang Commission on Elections, they conduct preliminary investigation on all election cases under the Omnibus Election Code 1987 Constitution. Mandates the COMELEC not only to investigate but also to prosecute cases of violation of election laws. We have also the PCGG or ang tinatawag na Prosecution for Violation of Republic Act 3019 or the Anti-Graft Law and Republic Act 1379, the Unexplained Wealth. The Office of the Solicitor General and can legally represent respondent government officials in preliminary investigation. Is the Prosecutor's Office on charges of violations of the Anti-Graft Law. So, meron din tayong tinatawag na tanod bayan and his assistants. Hindi sila yung mga barangay tanod. Ang tanod bayan ay ang mga ombudsman o ang taong tanod bayan ng Pilipinas. Sila yung responsible sa pag-imbestiga at pagpo-prosecute ng mga Philippine government officials who committed especially graft and corruption, kagaya ni na Imelda Marcos at Ejercito Estrada. Meron din tayong military tribunal na governed by the Articles of War.